One of the organisations which argued as a friend of the court, the lawyers call it an amicus curiae, was the Council for the Advancement of the South African Constitution. Their Executive Secretary is Lawson Naidoo. Lawson, good afternoon. Thank you for your time. You argued as a friend of the court. Do you believe the Constitutional Court's come to the right decision here, that Zuma is not eligible to be a Member of Parliament?
Good afternoon, Stephen. Thank you. Yes, it was quite clear to us from the very beginning that the wording of Section 47(1)(e) was very clear, that its plain meaning was that Mr. Zuma would not be eligible to stand as a candidate in these elections because he had been convicted and sentenced for an offence that carried a term of imprisonment of more than 12 months. And I think, as Justice Theron explained in the judgment this morning, that one needs to look at the purpose of that disqualification criteria. And it is about protecting the integrity and the dignity of the National Assembly, that we as a law-abiding society have deemed it that somebody who has broken the law of sufficient seriousness to get a sentence of more than 12 months is not a fit and proper person to serve as a member of the National Assembly. And they took that plain reading of the constitutional provision and said that Mr. Zuma's conviction fell within the ambit of that he was not therefore eligible, that the arguments that had been upheld in the electoral court, firstly, that it was not a sentence within the ambit of 47 because it was non-appealable, was incorrect because the section doesn't give a right to an appeal. It simply says when the sentence is actually deemed to be final after an appeal process, if one exists, where one didn't, such as in this case, it became final and binding immediately. So, you know, the court's judgment was very clear. I think it was important that it was a unanimous judgment of the court. And secondly, the court must be commended for having put together this judgment in just over a week.
Lawson, I don't know if this is fair on the electoral court, but, I mean, they came to a decision. It was interesting watching journalists like myself report on it. I think I used the word surprising many times. That usually means in journalistic speak that we don't quite understand how on earth this happened. Now, it was 5 judges in the electoral court, 3 judges, 2 professors, but sitting as judges in that court, who then ruled one way. The Constitutional Court unanimously goes the other way. I mean, is it fair to ask questions about the electoral court? Was this just one of those things that happens in courts sometimes?
Well, I think it is one of those things that sometimes happens. We certainly hope that it doesn't happen too often. And I think, you know, there were some creative legal arguments that were put forward both before the electoral court as well as before the Constitutional Court by the MK party and Mr. Zondo's legal representatives. And I think the electoral court, got caught up in some of those arguments and came to conclusions that were really not reasonable or justifiable. And I think the judgment of the Constitutional Court today makes clear that a simple reading of the constitutional provision, understanding the purpose and nature of those provisions, would mean that the interpretation that the electoral court placed itself, undermined the very intent and spirit of what the Constitution was seeking to achieve. So I think it was important that we got the legal clarity today, that it's a reaffirmation of the rule of law and of the independence and the strength of the Apex Court, in the light of the fact that we must acknowledge that this was politically a very divisive case, if not legally.
One of the things about the electoral court was the position they were placed in. If I remember the sequence of events, they heard the case in Joburg. They had really about 20 hours to issue an order. The reasons for their order came later. So in other words, because of the election timetable, which had been gazetted, they were placed in a position in which they had to come to a decision very quickly in a case that had some complexity to it. Are we correct to sort of suggest that should never have happened, that they should never have been put in that position?
Well, I think, an election is run, as you know, Stephen, according to a very strict timetable from the date of the promulgation of the election date. There's a very strict timetable that the IEC has to put in place and stick to in order to deliver free and fair elections. And we've got to respect and understand that. And yes, in this context, the electoral court, as was the Constitutional Court, placed in a situation where they had to hear a matter that was argued over, a long period of time. and had to come to a decision and a conclusion very, very quickly. Now, having announced its order, the Electoral Court then spent some time, a couple of weeks, before it put together the judgments. There were 3 separate judgments in that case. And quite clearly, after today's decision of the Constitutional Court, we now know that all 3 of those judgments have been overturned, and they had all gotten it wrong, albeit for different reasons.
I'm fairly certain, let me just go back a little bit, as you point out, it was a unanimous ruling of the Constitutional Court. How important is that? I mean, this issue is now over, finished and clear, correct?
It is. I think it is important that it was a judgment of the court, that it was unanimous, and the justices were not divided on this issue. And I think having read the judgment now, it's a very clear, concise, and well-reasoned judgment that really says, this is what the purpose of the provisions are, and we've got to understand, interpret and understand those provisions in the context of what they are seeking to achieve. And that leads us to only one conclusion: that those that have broken the law to such a serious extent that it requires a custodial sentence of more than 12 months should not be eligible for membership of the National Assembly. And that any remission of that sentence that's put in place has no impact on the actual sentence that was imposed by a court or a judicial officer.
I'm sure there'll be claims from some quarters, maybe from within MK, maybe somewhere else, to say that one of these sort of unfairnesses, or that former President Zuma has been victimized by the court because it was some of the same judges who made the initial decision to send him to jail that then sat in this case. Now, there was a court application around that. It was thrown out by the Constitutional Court. So legally, every correct sort of procedure has been followed. But are you concerned that that argument is going to come at a time when the judiciary has been attacked from politicians from various sides?
Well, it's an argument that I'm sure will resurface again, Stephen. But, as you say, there was a formal application for recusal of 6 of the judges of the Constitutional Court because they had sat in on the contempt case where the court found him guilty and sentenced him. The court gave its reasons for rejecting that recusal application as part of this morning's judgment. And what was interesting is in the hearing last week, Justice Turon, who read out the judgment today, actually said that even though she was in the minority in that the contempt case, she was bound by the decision of that, and the court was not reinterpreting that judgment, but on the basis of that judgment had to interpret the provisions of Section 47(1)(e) of the Constitution. So they found that they were not in a conflict of interest position. There could be no perception of bias, that these are judges that are able to apply their minds to the legal issues that confronted them in this matter. So yes, there will be some political fallout, and there'll no doubt be accusations of bias and political posturing by the court. But I think the judgment ought to speak for itself. It's clear, it's reasoned, it makes sense, and it's a proper interpretation of the Constitution.
Lawson Naidoo, thank you, Executive Secretary of the Council for the Advancement of the South African Constitution. I do appreciate the time. Well, that's